Good morning, everyone. Welcome to our series of talks this week for Insolvency Week. I'm grateful to you all for joining us, and we've got a great program of talks for you throughout Monday to Thursday this week, culminating on Friday with a plenary session where I hope we can have a good discussion of any of the issues that come up. So kicking off today, we've got talks by Rob Mundy and Natalie Kearney. So without further ado, thanks for joining us, and I'll hand over to Rob.
I'm going to talk this morning about directors' fiduciary duties once a company goes into administration or liquidation. We all know that directors owe fiduciary duties when a company is solvent, and that those duties are modified once a company is insolvent or likely to become insolvent. But what about once the company has entered administration or liquidation? This case, System Building Services Group Limited, decided just over a year ago, dealt with that issue and decided directors do owe fiduciary duties after a company goes into administration or liquidation. I think it's fair to say that the reactions to the case were mixed. If you look on the legal blogosphere, you'll see it was described as landmark and groundbreaking by Carson McDowell. Charles Russell Speechley said the judge's approach was a significant development and a departure from established practice. On the other side of the coin, DAC Beechcroft said the decision helpfully clarifies the law. R3 apparently said it merely underscores what most of the profession felt was already the position. And Holman Fenwick Willen said that any doubt about the principal legal issue has been firmly laid to rest. To understand this case, and we'll understand the case before we look at the law in detail, to understand the case, it's important, as it always is, to understand the facts. The company owned a house in Billericay. The company went into administration and then liquidation, and the insolvency practitioner appointed was Gagan Sharma. Soon after the company went into administration, Mrs. Sharma got an independent valuation of the property. That put its value at $195,000. That was probably on the low side. The single joint expert appointed in the litigation said it was worth £50,000 more than that. The director, Mr. Mitchie, agreed in principle to buy the property for proper value. But no price was agreed, and the sale for some time wasn't progressed. After a while, HSBC started chasing because its mortgage was going unpaid. And then, against that background, in July 2014, all of a sudden, Mr. Mitchie, the director, offered to pay $120,000, and Mrs. Sharma agreed. The sale went ahead at that price. After the Top Brands litigation, Stephen Hunt took over many of Mrs. Sharma's cases, including this one, and he sued the director, seeking to unwind the sale. We'll come on to the legal analysis in a moment. For the time being, just the result. Insolvency and Companies Court Judge Barber found that the director was liable and unwound the transaction, ordering him to restore the property, giving him credit for the £120,000 purchase price and $20,000 he'd spent on improvement works. I'm interested in your views on whether you think that is a fair result. There's no right answer to this. I'm not asking you what the law is, but what you think it should be. Should the director, Mr. Mitchie, have been liable on those facts? 3/4 of you think the answer is that he should have been held liable. Now, let's imagine Mr. Mitchie had resigned as a director just before buying the property. Would that change your views? Should Mr. Mitchie have been held liable even if he had resigned as a director just before buying the property? Interestingly, almost exactly the same answer. Somewhat perversely, this is probably just a tweak of some people not voting second time around. Perversely, as a percentage more of you think he should have been liable if he'd resigned, or maybe you think that shows a guilty mind. 77% this time thinks that he should have been liable. Now, it seems to me that there's a perfectly straightforward route to finding the director liable to the result that the majority of you think should have been given. The liquidator, Mrs. Sharma, was a fiduciary. She owed the company a duty to act in the way she considered in good faith would best promote its interest. There were sensible grounds for alleging that Mrs. Sharma knew this transaction would not benefit the company. The independent valuer had valued the property at $195,000, and there does not appear to have been much basis for questioning that valuation. If the market price was $195,000 and Mrs. Sharma knew that, did she breach her fiduciary duty by selling at $120,000? Sounds to me that that would be a decent argument. And the judge found that Mr. Mitchie knew that he was getting property at a significant undervalue. There was a proper basis for saying that he knowingly received property paid away in breach of trust. In other words, the conventional route, to my mind, would be to seek to establish primary liability against Mrs. Sharma and then seek to establish liability against the director, Mr. Mitchie, as an accessory. That wasn't the approach that the applicant in the case took. The company didn't sue Mrs. Sharma. The reason for that was that she was bankrupt. Nor did the company allege any wrongdoing on her part. The reasons for that were less clear to me and may have been tactical, but that's what happened. Nothing was alleged against Mrs. Sharma. Instead, the company alleged primary liability against Mr. Mitchie. It alleged that he was in breach of his duties. The applicant said Mr. Mitchie owed his duties as a director even during the administration and then the liquidation. And Mr. Mitchie breached his duty under Section 172 of the Companies Act 2006 because he did not believe the transaction was in the best interest of the company. So that was the approach taken on the applicant's side. The respondent's position was striking too. In his points of defence, Mr. Mitchie admitted that he owed the duties under sections 172 to 177 of the Companies Act, his general duties as a director, even after the company went into liquidation. Thinking better of it, his position shifted in his skeleton argument. To avoid resigning from the admission, Mr. Mitchie argued that while he owed the duties during liquidation, the duties did not apply to the sale. That was the skeleton. At trial, well, the judge describes Mr. Mitchie's counsel as having adopted a number of differing positions on the existence and scope of the duties at various stages of the trial. The final position that his counsel adopted was that the duties survive the company going into liquidation, but only apply in respect of any exercise by that director of his powers as a director. What did the judge make of it? The judge noted that the points were not argued as fully as they might have been. She noted that there appeared to be little authority on the question of whether a director owes duties once a company goes into administration or liquidation. What did she decide? First, she rejected the argument that the application of the duties is dependent on the exercise of a director's powers. She noted that the duty under Section 175(2) of the Companies Act, the duty not to exploit property, information, or an opportunity that belonged to the company in equity. She noted that duty applied even after a director resigns. A fortiori, it cannot depend on the director exercising his powers. Second, she noted that the Companies Act does not say that the duties end on the company going into administration or liquidation. Third, she said that the equitable principles which the Companies Act codified were sufficiently flexible to apply after liquidation. Fourth, she noted that directors are not removed from office on administration or on CVL. And she came to the conclusion that the director's duties did apply after liquidation and found that Mr. Mitchie was in breach of his duty to act in the way he considered in good faith would best promote the success of the company. Is that analysis right? It might be worth looking at some analogous situations. The first thing that's striking about the decision is that it suggests a director owes duties to the company when dealing at arm's length with the liquidator or administrator. So it might suggest that when a director is buying the business of a company in a pre-pack, the director has to act in the interests of the company. How does that manifest itself? Does the director have a duty to negotiate both sides of the transaction, to haggle himself up to the highest price he would pay? And if he does not, does he have a duty to pay a fair price, even if there's no market for the company's business? And if so, how do you possibly work out what a fair price is? That, in my view, is all rather unsatisfactory. A more extreme example: what if the liquidator or administrator sues the director and they negotiate terms of settlement? Does the director owe a duty in that negotiation to act in the best interests of the company? If he's offered the opportunity to settle for a pittance, does he have to turn it down? Does he have to ensure that the settlement terms are the best the company could achieve, or ensure that the settlement terms are fair? Neither of those possibilities seem workable to me, but it's hard to see a principal distinction with the facts of the system building services case. Another question, the question I asked you earlier: what if Mr. Mitchie had resigned just before the sale? If that had been the case, he wouldn't have owed the duty under Section 172. And on the way the case was pleaded and argued, the result would have been different. Well, that seems rather arbitrary to me, and from your answers to my question earlier, it seems you agree. So if probing at the case in this way raises some doubts, is there some relevant authority on the point? In system building services, the judge noted that there was very little authority on whether and when a director owes duties once a company goes into administration or liquidation. But counsel's search for authority was narrow, looking, it seems, for insolvency law cases. There's a rather richer mine of company law authority on situations in which a director's duties do not apply or are attenuated. Cases that establish that a director does not owe fiduciary duties when voting his shares as a shareholder, a complicated line of authority that deal with the question of what duties apply when a director negotiates a transaction with the remainder of the board. But let me just mention one case, perhaps a particularly helpful analogy. That case is Plus Group and Pike. You may well be familiar with it. It's a company law case. It concerned a company with two directors, Mr. Plank and Mr. Pike. They were also the company's shareholders, and they held 50% of the shares each. Mr. Pike had a stroke. After he recovered, Mr. Plank wanted him out. He wanted him to resign as a director from the trading subsidiaries. Mr. Pike refused. Mr. Plank excluded Mr. Pike from management, moved his office, denied him access to company records, and stopped any payments being made to him. In response, Mr. Pike set up in competition and made a success of it. The company, through Mr. Plank, sued Mr. Pike for breach of his director's duties and sought an account of his profits. The company argued that it was a breach of Mr. Pike's director's duties to set up a competitive business while still a director. The trial judge and the Court of Appeal found in the defendant's favour. They said he was not in breach of his fiduciary duties in the circumstances. Lord Justice Brooke said that Mr. Pike had been effectively expelled from the company and had not used any confidential information or company property to set up in competition. He'd not breached any fiduciary duty. Lord Justice Sedley said that Mr. Pike's duties had been reduced to vanishing point by his exclusion from management. He said his position was nominal in that he was entirely excluded from all decision-making and participation in the company's affairs. For all the influence he had, he might as well have resigned. Lord Justice Jonathan Parker said that had Mr. Pike formally resigned, his resignation would have done no more than reflect what had in practice already happened. So if a director who is forced out of management by a co-director ceases to owe fiduciary duties, why not a director who's removed effectively from management because the company goes into liquidation? Again, it is difficult to see a principled reason for distinguishing the two situations. So if we step away from the system building services case and consider first principles, what conclusions might we reach? Well, the first principle, the first thing to note, is that fiduciary duties are a control on the director's powers and the privilege of his position. It would seem odd if they operate in full in a situation where the director's powers have come to an end. The second thing to note, in my view, is that each duty deserves separate consideration. In system building services, Mr. Mitchie argued that none of his duties applied to the sale or applied after the company went into liquidation. He would have been better off arguing that some duties ceased to apply. The better view might be this. The duty not to exploit maturing business opportunities applies when a director's powers are at an end. Section 175 of the Companies Act tells us that. The duty not to accept a bribe probably does too. The duty to compete probably does not. Plus Group and Pike tells us that. What about the duty under Section 172 to promote the success of the company? Well, that's a duty imposed because a director has powers to act on the company's behalf. And it does not apply, for instance, when a director is voting his shares as shareholder. unless the liquidator has allowed the director to exercise management powers. It's difficult to see why that duty should apply after liquidation when the director's powers come to an end. Where does all this take us? Well, I doubt whether system building services would be followed if the point were argued fully. I expect the court would find that directors owed some duties after the company goes into liquidation or administration, but not the duty to act in the best interest of the company, or at least not when on the other side of a transaction to the administrator or liquidator. For the time being, though, some practical points to consider. For insolvency practitioners, cases of exploitation of information and opportunities aside, if you're tempted to allege a breach of a director's duties after liquidation, it's worth considering whether there's another way of framing the case. I think there often will be. If you're on the other side of the insolvency world, advising directors, you might well want to advise them to resign once the company goes into administration or liquidation. That frees them up to negotiate, to buy property from the insolvency practitioners without having to worry that they will be found not to have acted in the best interests of the company. I'm keen to answer as many questions as you might have. I noticed that one's come in on the Q&A already. If you've got others, please put them into the Q&A and I'll try to answer as many as I can at the end of the session. Now though, Natalie is going to talk on the topic, winding up petitions, where are we?
Thank you, Rob. Good morning, everybody. As Rob has said, I'm going to talk about winding up petitions and where are we. Those eagle-eyed amongst you will know that we're still awaiting news on whether the current restrictions in place are going to be extended. As of 9:29 a.m, before our webinar started, there had been no update. If that changes during the course of this webinar, you'll forgive me if I don't see that. So I'll give a short overview this morning of SIGA, the usual procedure and where SIGA has left us. What Brexit has done to the insolvency procedure, although I'm conscious that Marc's giving a talk on that this Wednesday morning, so I'm going to fly through that. And if you have any questions specifically on Brexit, I'm sure Marc will be able to assist with those on Wednesday morning. And in relation to SIGA, I'll be focusing on its impact on winding up petitions. If there are questions on SIGA more generally, tune in tomorrow morning for James Morgan QC's talk on SIGA administrations and the broader implications of SIGA. It's been, to use a phrase that many of us are probably sick of hearing, an unprecedented time in insolvency after the initial lockdown last March. Things are starting to judder back into some sort of motion, but it's probably going to be quite some time before we get back into what was business as usual. Giving a little bit of a whistle-stop tour of the very basic principles before we get into the detail. You'll all be familiar with this. Winding up petitions are, as we all know, a nuclear option. It's not, as is drilled into us all, a debt recovery process. It's a remedy for creditors as a whole, a class remedy. And those petitioning creditors go in into the pot with all the other creditors, treated pari passu, with obviously the usual caveat for secured creditors. The usual questions will still remain relevant. So is the debt the required level, so in excess of £750? Is your creditor unable to pay? Is this nuclear option the best option, or is giving more time for payment a better option, particularly if there's going to be an IP appointed and their costs may in fact reduce the assets that are going to be available for the creditors? And most importantly, perhaps, is the debt disputed? And if it is, then as you'll all know, it's likely to be dismissed as an abusive process, and you may in fact face indemnity costs as the petitioner. So, looking firstly at the pre-pandemic process, as you'll all be familiar with, those are the usual grounds set out on the slide there. So you have an unsatisfied statutory demand, unsatisfied judgment debt where execution's been returned unsatisfied, And then the usual third and fourth points, your cash flow insolvency test and your balance sheet insolvency test. As you'll all be aware, we don't require statutory demands for winding up petitions, unlike in bankruptcy petitions, but they're generally used. A letter before action, for example, can be sufficient, as we'll come on to. But SEGA has significantly curtailed the use of statutory demands. So what has SEGA brought in? So we have temporary modifications to the winding up proceedings, and we're looking at Schedule 10 of the Act for where we find all the detail for winding up petitions. Now, as I say, the eagle-eyed will know they expire as it stands on the 31st of March of this year at midnight. There is rumour, and it's nothing more than rumour, that they're going to be extended again. Many of you will remember that when they were last extended in December of last year, it was described as the final extension, but we've all heard that before. So I have no special insight, unfortunately, as to whether they are going to be extended. It does seem likely, but it's simply speculation at this point in time. I note, for example, furlough obviously goes until September of this year, and we have the commercial tenancy evictions extension to June this year. If I was a betting person, I'd say probably June, but we shall have to wait and see. Now, as I say, statutory demands are first. So any statutory demands from the 1st of March of last year can't be relied upon as the basis for winding up petitions. And that's irrespective of whether COVID-19 has had an impact on the debtor company or not. And they simply just can't form the basis of your petition. Creditors are then further restricted from presenting petitions after the 27th of April of last year, except in certain circumstances, as we'll come on to. And those circumstances are the coronavirus test. So unless the petitioner can demonstrate either firstly that there has been no impact on that company, the debtor company, as a result of COVID-19, then you'll pass the coronavirus test. You should be able to wind that company up on the grounds of insolvency, subject to the usual caveats. Or alternatively, that the circumstances giving rise to your petition, the insolvency element, would have occurred even if not for COVID-19's impact on that company. And we're tending to see more of the latter limb, perhaps understandably, in relation to, for example, unpaid invoices from pre-pandemic times. It's worth noting that it's not a high hurdle. There was a case actually recently before Deputy ICC Judge Passfield and PGH Investments Limited Newing in the High Court Chancery Division. It's a very low threshold, in fact. There's no need to show that the financial position of the company has significantly worsened as a result of COVID-19, only that it has worsened. And there was actually a case last week on the 18th of March before ICC Judge Baster, A and B is the name of the case. It's in the weekly law reports. And in short, the petitioner's case was that there was a petition debt arising out of an order on the 14th of November 2019 for a sum of money that was due by the 17th of November. It hadn't been paid. They served a statutory demand. They didn't rely on the statutory demand because of the restrictions that were in place, but there'd be a demand for payment. And the issue in that case was whether it was likely the petitioner would succeed on the winding up petition, having regard to SEGA, because this was all considered at a preliminary hearing. And we'll come on to what's looked at as a preliminary hearing in due course, because it's one of these procedural changes in the practice direction. But in that case, the petitioner said, well, they're unable to pay the debts as they fall due. Under the Act, applying the coronavirus test, that would have arisen in any event, because there's not been an impact on the company. And in that case, it did appear that the company was facing insolvency in November of 2019, so pre-pandemic. And in fact, the company didn't attend the hearing, but did give evidence to say that it made settlement proposals for this debt. They accepted the settlement proposals have been accepted by the petitioning creditor, but they've just not been adhered to, as perhaps is usually the case, unfortunately. The company does appear to accept that it had been insolvent at that date in November 2019, but then emailed the court and referred to company growth as the reason why it shouldn't be wound up. Now, the court then said, well, in that case, you're accepting that in November 2019, you were in a position of insolvency and you've grown since then. So you cannot say, under the coronavirus test, your position has worsened. You seem to be, in fact, proving the opposite. You've improved since November 2019. And so, unfortunately, the position of the debtor company, in fact, in those circumstances, made it more likely the winding up order would be made, looking at the coronavirus test principle, because in fact they hadn't had a worse financial situation as a result of COVID-19 than they had pre-pandemic in November 2019, when the debt in fact had fallen due. It's also worth noting that there has been a change in the SIGA to the commencement date of winding up proceedings. So as you all know, pre-pandemic and pre-SIGA, the commencement date was the date of presentation, so when your OR's deposit was paid. We now have, at paragraph 19 of Schedule 10, change to that, in that the commencement date will now be the date that the order is in fact made. So what does it mean in practice? What are we dealing with? Well, there's the new practice direction to look at, which I've referred to previously, which talks about these preliminary hearings. It's the Insolvency Practice Direction relating to the Corporate Insolvency and Governance Act 2020. It's a nice and snappy title. And I'm also going to look at the quirks that have arisen as a result of that practice direction. So to be clear, the practice direction on SIGA is a specific practice direction. It has effect from when the Act came into force from June last year. It's separate to the temporary insolvency practice direction, which was updated around the 2nd of October 2020. And it's separate to the usual insolvency practice direction we're all familiar with as well. So just to keep things simple, there are now 3 practice directions to go looking at when we're dealing with insolvency proceedings. So as I say, it has effect when SIGA came into force, and it sets out these new stages and the coronavirus test. It sets out what the petitioning creditor should expect and what the debtor company should expect from the court when they're dealing with petitions during this relevant period. So what happens? So you file your petition if you're the petitioning creditor with your evidence for the coronavirus test. So either firstly, no impact on the debtor company, or secondly, and as more commonly seems to be the case, even if COVID's had an impact, these circumstances would have arisen anyway. For example, you have an invoice that predates the pandemic and it simply hasn't been paid. So you file your petition with the evidence, pay your court fee and the OR's deposit, and you serve the petition as you usually would. And then the debtor will file any evidence in response. It's most likely this is going to be dealing with the coronavirus test. And then you'll find that you are listed by the court for a 15-minute non-attended review hearing. I've seen some of these orders floating around. They can be a little bit confusing in the wording as to whether in fact you are required to attend, because it may in fact attach details as to the generic listing for a remote hearing. But they are non-attended review hearings. The judge looks at the papers and considers those against the coronavirus test. So what are they looking at this non-attended review stage? Well, I'm told that it's looking at, firstly, the petition itself, whether it's been served. Secondly, whether any evidence has been put in for the coronavirus test, and also whether there's been time for the debtor company to put in evidence on its own behalf in response to the petition on that coronavirus test. And then the judge will take a view as to whether a winding up order is likely to be made. Now, if it does look at if the papers are looked at by the court and the judge thinks, yes, it's likely that the order will be made in any event, then you'll be listed in the usual winding up list. If the judge isn't satisfied, then they will list a preliminary hearing, which is what I refer to as being dealt with in the A and B case. And the judge will, in that case most likely be looking at the coronavirus test. You may put in further evidence, you may deal with the evidence that's already there, but you're looking then at, has there been an impact from COVID? Would this have arisen regardless of any impact? And so on. Again, if at that hearing the judge says, well, actually, having heard the evidence, I am satisfied, an order is likely to be made, they will list it in the usual winding up list. If not, you may find your petition is dismissed. And it's only once this has been listed in the usual winding up list that you can then advertise the petition. That is a big change to be aware of. No publication of the details, the existence of the petition, until the court has looked at it and is satisfied that an order is likely to be made. So what's the impact that this is having on insolvency proceedings? So firstly, opportunism. Is it the case that debtor companies are using this opportunistically to avoid being wound up? It was raised actually recently at the Leeds Business and Property Courts meeting, and there was a suggestion by one of the judges there that it wasn't a case that they were being abused per se. Companies were perhaps putting forward questionable arguments, but they put it no higher than that. But they are entitled to put forward their best case. They're entitled to put forward arguments under SIGA, and that does seem to be what's happening. As one would expect, it's a very case-by-case basis, but where the debt does arise from an invoice, for example, that predates COVID, there's a real uphill struggle to say that there's been, the circumstances wouldn't have arisen but for COVID. But again, it will depend on the facts of the case. And then what about quirks? I mentioned these earlier. There are petitions presented by non-creditors, for example, but on insolvency grounds. And everyone knows SIGA is aimed at creditors' petitions. So what, for example, happens where you have a director petitioning for voluntary liquidation, for a winding up order, where voluntary liquidation hasn't been possible? Does the SIGA practice direction apply? Do we have these non-attended review hearings and preliminary hearings? It does appear that the court are listing such petitions for the 15-minute non-attended review hearing. This would appear to be right. Looking at the practice direction wording, paragraph 2 provides that it applies to winding up petitions presented during the relevant period against a registered company under section 1221F, as you'd expect, the insolvency ground. And therefore, although it's a creditor's petition, it would appear to be caught being a petition presented within the relevant period and on the basis of insolvency. So even though it's not a creditor's petition, the wording of the practice direction does suggest it will be caught by that filtering process. And it does appear most likely that in those circumstances, the court will look at it at the non-attended review hearing, see that it's not a creditor's petition, it doesn't need to look at the coronavirus test, and therefore list it in the usual winding up list. But again, I've only seen this quite rarely at present. If anyone has experience of that taking place, by all means reach out to me after this or for Friday's plenary session. I'd be interested to see how other people are finding the courts are dealing with that scenario. As an aside, in relation to publicity, as many of you will have realised, this does mean we have the risk when you can't talk about petitions being presented until they're in the usual list, that you have multiple petitions against the same debtor company. And that usually obviously runs an adverse cost risk because you're required to check that that there are no other petitions when you present your petition. But the SIGA practice direction does seem to envisage this occurring. It provides for petitions to be heard together, whether against the same company, if they've passed the preliminary hearing or non-attended review stage should be listed. So I wouldn't expect there will be adverse consequences if you find that your petition is second, third, fourth in line, where you couldn't have known about the initial petition having been presented. So what about Brexit? So if anyone forgot, we left the EU on the 31st of January last year. Transition period ended on the 31st of December last year. And for a detailed look at the impact of Brexit, as I said earlier, Marc Brown's giving a talk on Wednesday morning at 9:30 as part of our Insolvency Week. So he'll be looking at that in greater detail. But for our purposes, if the winding up proceedings started and were opened before the 1st of January 2021, then the EU insolvency regulations will still apply. And after that, we're into what are often referred to as the retained insolvency regulations. Those are these, again, snappily named the Insolvency Amendment EU Exit Regulations 2020. The primary purpose is said to be retaining the existing provisions, but if anyone's actually read them, they don't seem to retain much of the existing provisions. From the 1st of January, as I say, there'll be changes to what we know as main and secondary proceedings. Broadly speaking, what were main proceedings will become COMI proceedings. What were secondary proceedings will become establishment proceedings. And the standard forms have been amended accordingly, so you'll be able to mark them as being COMI rather than main, establishment proceedings rather than secondary proceedings. And the witness statement as well has been changed, the verification witness statement, to update and reflect the new changes as well. So where does that leave us? So as we're going forwards, you ask usual questions before you prepare a petition. Don't try and rely on stat demands at present. We'll see whether that changes after the 31st of March or not. Have your evidence ready to go on the coronavirus test, either no impact whatsoever on the debtor company or some impact, but it doesn't matter because this would have arisen anyway. Don't advertise prematurely. and be ready for a potential extension beyond the 31st of March. As I say, I have no special knowledge of that, but it does seem likely. But what's going to happen post-SIGA? Well, post-SIGA, there's the expectation that floodgates are going to open. We're going to see a lot of petitions, lots of creators waiting with stat demands for that date. But as I say, it's unclear if the government's going to want this cliff edge, particularly given there's been quite a lot of support, as we've seen through furlough schemes and bounce back loans. There was talk, as I said, at the Leeds Forum about HMRC petitions, for example. The government's going to be winding up via HMRC companies, where it's also giving them bounce back loans. And so it seems a rather strange set of circumstances we find ourselves in. So it remains to be seen if we're going to see, sort of, rather than a cliff edge, a steady winding down of the winding up moratorium, as it were. Also, may be interesting to see if judges are going to be more sympathetic to, can we adjourn this, please, to give time to pay, in circumstances where companies can say, well, I can pay it if given time. And because my previous issues were COVID related, my company was in dire straits, but now that the restrictions have been lifted, I expect to be able to pay this. We'll have to wait to see whether adjournments are more likely to be granted. Anyone that's regularly dealing with winding up petitions will know that quite often first hearing ends up in an adjournment anyway, to explore less terminal options for the company. So we'll see if that is still a sympathetic ear. And generally speaking, it would always be, as usual, more sensible for creditors to consider if giving time to pay is the better option in these circumstances, rather than going for the terminal sort of option of liquidation. Especially, but I do accept in these cases, all companies, or at least most companies, have been impacted by COVID-19. So simply saying wait for your money to come in is not always an option. It's certainly not as easy as perhaps it once would have been, given that the broad impact COVID has had on companies.
Thank you very much, Natalie. I look forward to your follow-up talk in due course, entitled Winding Down the Winding Up Provisions, given that you've snappily given yourself that title. That's great. So thanks very much to Rob and Natalie. We've had some questions come through on the Q&A. I'll start with the questions for Rob. Rob, you're asked, what about the significance put on resignation in Buyers Against Chen?
That's, if you don't know, that's a recent Privy Council case, not yet reported, where it was found that a director had not resigned, even though she'd written a resignation letter. A rather odd case. The director sent a letter, but then carried on acting as director. It was found at first instance that she was a de jure director, even after her resignation letter. And the Privy Council upheld that decision, finding that as a sole shareholder of the parent company, under the duomatic principle, she was entitled to accept the withdrawal of her own resignation, which she must have meant. What does it tell us? Well, it tells us this, that resignation is important and brings directors' duties to an end for the most part. Otherwise, why argue the case? Unless, of course, somebody goes on to act as a de facto director, which was the fallback argument. And I suppose, what do I take from it? My view doesn't change much. If resignation brings the duties to an end, for the most part, that suggests to me that effective exclusion from management also ought to have a very significant effect.
And Mr. Watson says, what about the articles, and what about if they don't allow directors to resign within a prescribed period?
Well, I mean, Julian's right that articles often prescribe minimum number of directors, sometimes notice requirements. Articles, even if they have prescribed minimum numbers of directors, that doesn't normally stop a director resigning. Ultimately, if a company ends up with no directors, the company commits a criminal offence, but the resigning director does not.
And finally, for you, Rob, I think, what about if we've got two directors and one director pushes out or excludes the co-director? Does that result in the excluded director still being liable if the excluding director diverts business or acts contrary to the interests of the company?
Yeah, so I think that if we imagine Plus Group and Pike, if after Pike had been excluded, what if Mr. Plank, still in control, had diverted business to a new co? Not that uncommon a scenario, perhaps more common than the facts of Plus Group and Pike. Well, what would have happened if Plank, still in control, had diverted the business to a new co? He, Plank, would certainly be in breach of duty. What about Pike? Directors have, to a certain degree, collective responsibility. Well, if he had stood idly by, not attempting to get involved in management, not attempting to prevent it, he'd be liable in the same way as, well, you often get a spouse on the board to collect the director's remuneration, but who takes no interest in the business, such as a spouse in those circumstances would be liable for doing nothing. But if you're in a situation like Mr. Pike was in, and he was doing what he could to get involved in the management of the business, but thwarted by a director who takes the law into his own hands, he wouldn't be liable. He wouldn't have to exercise his powers as a shareholder, so he wouldn't be expected to have to bring an unfair prejudice petition or something like that. If he did what he could as director, which may, when somebody's taking the law into their own hands, not be very much, then he wouldn't be liable.
Thanks very much, Rob. Natalie, a couple of questions for you. Firstly, you referred to evidence being filed together with the petition. Some people's experience of petitions is that there's no real evidence, just a declaration about the coronavirus test within the petition itself. What would you say about that?
So you aren't required to put in any separate witness statement. For example, you put your details as you normally would in the standard form for detail of your debt. You fill in the standard declaration. I have seen parties putting in witness statements behind the petition, setting out the elements of the coronavirus test. It would seem sensible if you want to get through that, if you think you've got an obvious case and you want to get through that non-attended hearing straight into the winding up list, having your evidence clearly set out would perhaps be more beneficial than having to find your preliminary hearing instead, incurring the cost of having to argue it to get it then in the standard list.
I suppose it depends on the circumstances of the case, isn't it? And what you say takes it outside of or passes, sorry, the coronavirus test. Is it simple, or is it perhaps a little bit more complicated and would benefit from a bit more explanation in evidence? Another delegate says, my experience of a 2021 petition in Birmingham is that the court didn't seal it review hearing, so there was nothing official or sealed to serve before then. Should it have been served anyway?
I think this is a problem with court approaches. So I've seen the same thing happen with Birmingham. They haven't sealed it, or when they have decided to seal it after the review hearing, they've sealed the unsigned petition instead of the actual signed petition. Theoretically, because the indication that I've heard from the lead judges, for example, is at that review hearing, they want to see evidence from the debtor company. They should know about the petition. If you don't serve it, they don't know about it, there'll be no evidence. So you may find you have a preliminary hearing then because there's nothing from the debtor company, unless it's a very straightforward, as Marc said, you've got, for example, invoices that predate the coronavirus pandemic. But I'd say good practice, serve it, let them know about it, and then you avoid the chance of getting pushed off for a preliminary hearing.
Yeah, there is a difference in approach. I think in London, the petition gets endorsed with the first or the non-attendance PTR date, but there's no reason why it's ex parte. It's inter partes between the company and the petition, so no reason not to serve it. Our last question for you then, Natalie, is what about a complete try-on by creditors willing to take a punt despite the provisions of SIGA? What do you think would happen with a petition like that?
I suppose what's the nature of the punt? If we're talking about it's a debt, it's still, you have the usual provisions of, is it disputed? If you're trying it on, you're still going to face the abusive process arguments, and you're still going to face indemnity costs.
But it's right to say, isn't it, that, or if I ask you this, where does the burden of proof lie on the coronavirus test? Really, it's for the company to show that the coronavirus test is not met, such that the petition shouldn't proceed. So I suppose one could say that the creditors are entitled to take a punt, see if the company responds with its coronavirus issues, but if it does so, it takes the risk that the company will easily satisfy the coronavirus test, and the petitioner is liable in costs.
Yes, yeah, I agree. It's the usual cost risk. They take a punt there at risk of cost if the court thinks they've taken a punt, in view on costs.
Great. Oh, well, here we go. Another one for you, Natalie. Are you seeing any directions regarding advertisements? I had a case which was clearly contested, but the creditor advertised anyway prematurely. Oh dear. Thought about that?
I haven't, I confess, in any directions given as to advertisement. But the practice direction is clear. As a CG, you shouldn't be advertising it or revealing its existence to anybody until the court says that you can do.
Yeah.
That would be a direction, or there'd be some wording to that effect when it's listed for its listing in the usual winding up list. I don't know if you've seen any, Mark, those who've had.
I've not seen any advertised before they were meant to be. It brings to mind me, and I'm thinking on my feet, but potentially if someone advertises a petition where the rules say that it should not be advertised, and that causes loss to the company, which it could do, then there could be a claim against the petitioner for having advertised where they were not entitled to. Rob, any thoughts on that?
Well, and also apply for an injunction to prevent advertisement. I've had a case where we drafted the application notice, sent it to the other side, and they decided they would read the practice direction one more time.
That's very useful. Thanks, Rob. Well, I'd like to thank both our panelists today for their informative and well-researched discussions. I hope that helps everyone with their thoughts about these issues. This is just the start of our Insolvency Week this week. We've got more talks coming at you Tuesday, Wednesday and Thursday, ending with our plenary session on Friday, which I hope you can all join us for as many of those talks in the meeting as you can. But for today, enjoy the rest of your working day and the first working day in spring, and I shall see you all soon.